This is the current federal tax development for the week of June the 24th, 2024. Current federal tax developments are brought to you by Kaplan Financial Education and by your state Society of CPAs. I'm Ed Zollers, and we're here this week looking at what's been going on in federal taxes here as we get towards the end of June. And so this week we're going to look at three different developments. The first one will be the Supreme Court finally issued the ruling in the Moore case we've been discussing since last year when the court agreed to hear the case, also when the court actually had the hearing of the case, and now finally when the decision came down. And the decision is, although a 7-2 decision, it is a bit more divided than it may appear. But the key thing is it wanted to make very clear, as majority opinion does, that there's not going to be a major change in pass-through taxation. But it really does nothing to resolve the question that everyone believed was the real reason why this case was brought when it was, which was whether or not it would be constitutional to enact a wealth tax. That issue not decided. And while especially the concurring opinions and the dissenting opinions can give us a clue about how certain justices are likely to vote if a case like that came before us, essentially, except for the four that have, except for, I should say, the five that have issued some form of dissenting or concurring opinion, basically the other four are temporarily uncommitted. And since the five there, four of them, well, two clearly indicate they're probably lean to say it's unconstitutional. Two of them seem to lean very heavily that way. And one of the concurring opinions leans heavily the other direction. And that would leave the four justices that essentially said, we're not talking about this right now, on the fence. And those four are, interestingly, two of the more conservative justices in the conservative branch of the court and two of the liberal justices on the court. And they just decided, we're going to decide the case in front of us. And frankly, that case can be decided without worrying about any of these questions that could impact other things. But we are going to make it very clear that pass-through taxation is not at risk. It's not going to change dramatically. We also have the IRS issued interim guidance for two special distribution relief provisions found in the Secure Act 2.0. So we're going to take a look at those rules for the particular pair of distribution types that qualify. And it's a question and answer format that we will take a look at. Finally, we'll also get an IRS news release issued in response to a lot of pressure the agency's been under to say, what are you doing about employee retention tax credit claims? And the IRS has now indicated that, I think the best we could say about this is they will begin slowly processing claims. And it'll be very, very slow, except for maybe 10 to 20% of the claims they had on hand before the moratorium date. Those may very well be processed quickly, get their stuff at least relatively quickly later this summer. But everybody else is probably in for a long wait, or we discovered that another 10 to 20% may simply get rejection notices very quickly. We rejected your claim, and that'll also be a quick answer. And then you got to discover what you're going to do. So that could be interesting. But anyway, and everybody in the middle, yeah, you're just in for a long wait. So we'll go there. Let's start out with the Moore case we've been waiting on for quite a while. This case is Moore versus United States, Supreme Court case number 22-800. The opinion was issued on June the 20th. Now, we have been discussing this case ever since the Supreme Court decided to take up the case. The Moore case, if you don't remember, is a case that relates to the 965 transition tax that was enacted as part of the Tax Cuts and Jobs Act in 2017. And if you're thinking this is a long time after that law to be litigating this, yeah, it was, because while the 965 transition tax was the vehicle to allow this to get to court, it is fairly clear, and it was only a $14,000 tax. Gang, you don't take a $14,000 tax to the United States Supreme Court, because the legal fees to get your case before them after getting it through the lower court, the Court of Appeals, and now the Supreme Court to be heard, is going to be way over $14,000. And even if you were to win wholeheartedly, which is highly unlikely when you've lost twice in the lower courts, the Supreme Court may rule in your favor, but they're unlikely to give you legal fees. Yeah, or even tell the lower courts to do it. So, or to take a look at it, it's like, yeah, this obviously is not about the thing that it is technically about. The case is literally about the issue of the 965 transition tax and its legality, but it served as what was hoped to be a mechanism to get the question of whether the wealth tax, a proposed wealth tax, which did have some traction back when the Democrats had control of both the House and Senate. There were some discussions about it, but it never really got anywhere. And currently, with the current Congress, obviously it won't get anywhere. And my own take is it probably won't get anywhere without a radical change in Congress. But nevertheless, this case was there. And a concern some had, and literally I had too, was that this conceivably could cause a lot of collateral damage if they had actually decided it using the exact theoretical background that the Moores had. Because while the Moores were laser focused, or those who brought this forward, were laser focused on the wealth tax, nobody had considered, I don't believe, well, and it turns out when they got to the Supreme Court, the counsel for the Moores were trying to distinguish why the 965 tax was different than every other type of tax like this, which then would accept the obvious question, then, is the wealth tax also somehow wildly unique, or are we just with a place that it doesn't matter? So the case got messy toward the end, and it got messy when I was hearing it on oral arguments. But in any event, by a 7-2 opinion, the Supreme Court held that the tax was constitutional. As I expected, it appears pretty clear that certainly at least 4 justices, and as I recall, we just need 4 to grant cert. I have to remember, somebody can correct me on that if I'm wrong, but essentially 4 of them clearly wanted to deal with one thing where the Ninth Circuit had said realization is not required in order to basically tax income. It doesn't have to be realized. 4 of them clearly wanted to strike that term. I suspect some others did too, but in essence, only those 4 specifically indicated that's basically either is or almost certainly is a wrong ruling in their view. And that was why it got picked up. And so we've been kind of down this path just so that didn't stay around. That's probably the main accomplishment we had in this. There were 2 concurring opinions issued. So of the 7 who voted in favor of it, there were 2 concurring opinions, and one had a single justice wrote one, the other one had 2 justices on it. So 3 of the 7 justices agree with the result, but don't necessarily fully agree with the written opinion. So kind of the why. One of them clearly doesn't agree with the why. The other one was more of an emphasis, let's say, of issues, right? So that was how it gone. So Justice Jackson's opinion, and she was the only one who was in that opinion, essentially was emphasizing issues, talking about, that there should not be a realization requirement, and effectively, that the courts had to be very, very, very careful in messing with issues like this. There is a discussion of the Pollack versus United States case. That was the one that found the Civil War era and following income tax to be unconstitutional, which was actually a bit shocker because it took it many years before it did that. And certainly there was a lot of belief that, shall we say, questions about whether its analysis of direct versus indirect taxes was actually correct. And even the author, Justice Kavanaugh, who authored the majority opinion, seems to have real questions about that case as well. Whether it was properly decided to begin with, which kind of interesting means, was the 16th Amendment even necessary? But that's a whole nother long discussion, right? But he did spend more time on that than he did on the question of whether realization is required. So it's kind of an interesting opinion that way. But Justice Jackson makes that opinion. So pretty clearly, she would back the Ninth Circuit in saying that realization essentially is not a requirement for income to be taxed under the income tax, probably with or without the 16th Amendment. Finally, Justice Barrett, who is joined by Justice Alito, indicated that there is a realization requirement. They believe it exists. And that the real problem in this case is a very technical issue, that the plaintiffs, during, basically in arguing the case, had conceded that the subpart F tax is constitutional. And the problem is, as the majority opinion says, if subpart F is constitutional, there's no way the 965 transition tax isn't. because it's basically taxing the same thing. It just taxed it on a more deferred basis. So because of that, essentially they're saying, well, the plaintiffs fouled up their argument, so it doesn't matter whether or not, it doesn't matter if really this tax is improper, because, they just fouled up their argument. And we don't, since the burden's on them to prove that they have a right to a refund, because it's a refund filing case, essentially they would automatically lose the case. So kind of technicality. So if you look at it that way, what we really have here, you might argue, is closer to a 5-4 opinion in this regard. And again, but we don't know what Justice Barrett and Justice Alito would have done about pass-through taxes in general, and whether they would have carved them out in the same manner as the majority opinion. They didn't really say they would, but that's a whole different problem. So let's go ahead and take a look at this opinion. The main opinion stated that no determination was made on key issues, and this probably was disappointing to the plaintiffs, because they really wanted to have this be where we tried the issue. That would make it clear that a wealth tax would be unconstitutional. So if that was the point of litigating this, which it appears it was, it didn't work out well for the plaintiffs. We'll just place it that way. So they did not say whether realization is or is not required in the 16th Amendment. Now, I don't believe for a moment that those 4 justices who didn't issue concurring opinions don't have an opinion on whether it is or isn't. However, I do think those 4 realize that they got a way to decide this case without worrying about that. And so basically, 4 of them decided to stay quiet. 4 of them decided to stay quiet. The 2 who dissented, obviously, they have no need to stay quiet. But 3 of those that essentially agreed that we should sustain the Ninth Circuit felt the need to write and indicate they were kind of deciding this issue on their own. They also said we are making no claim whatsoever, and none of the 3 really did in the concurring opinion, whether or not any future tax that might be enacted passes constitutional muster. And this is the indirect reference to the wealth tax. So essentially, kind of slapping them. And I think this is a message to various groups who might want to try cases like this, to go find something and find something to try a tax before it's enacted. The court is sending a bit of a message here that they don't plan to do that, that they're going to avoid that if they can. So certainly don't, you can't apply this case to any other tax. It doesn't matter. That's not it. So that was key. And this is kind of how they constructed the majority opinion, right? In essence, everybody said, we come up with a reason why we don't need to decide this issue. And since we don't need to decide it, then basically we're not going to decide these issues. The problem, they said, is regardless of whether realization is or is not required to have something subject to tax, the income in this case is realized. As such, game over per the majority opinion. Now, as I said, 2 of those who are part of the majority opinion don't necessarily agree with that view, right? So now we're down to, as I said, more of a 5-4. But, or at least, they didn't say realization. What they said was the income was realized, but in their view, that's only true because the taxpayers conceded it. They didn't concede that it's realized otherwise. However, certainly 4 of the justices in the majority opinion that were a part of the opinion essentially say, yeah, this is an example of realization, period, right? The opinion does a detailed analysis of prior precedents and that make it clear and Justice Kavanaugh wrote the opinion that, in essence, Congress has the right to tax either the entity on the tax in question, or on the income in question, or could tax the equity holders, right? Now, they specifically said it didn't resolve the question where they could tax both. It's a different issue. But they did say that they could tax, either one. They can choose. And that was important because there was a lot of concern that had they decided that realization meant that you had to receive cash. The equity holder would have to be paid cash in order to have a realization event, cash received property, that would have totally upended the taxation in partnerships and S corporations. And yeah, the court and Justice Kavanaugh clearly was very concerned about that issue. You can read in the opinion, and I've got to presume that the others, basically at least the four in the majority, basically the majority probably was heavily leaning that way, shall we say. Or I should say, four of the seven who were not writing concurring, essentially we're going to protect that. I should say five of them. Five of the seven would have leaned that way, that we need to protect pass-through. So essentially they said, look, there's nothing unique about partnerships or S corporations that somehow specially allows Congress to impose a tax directly to their equity holders. They could do so with any entity. If Congress decided tomorrow that everybody who owns stock in a C corporation has to pay tax on the income passing through, we'd get rid of the C corporation income tax level, instead have everybody pay on pass-through, that would be allowable. They don't say that directly, but they effectively say it. Right? Congress do that. And tomorrow, Congress could change the law and say, you know what? Partnerships are going to pay tax at the partnership level, and all corporations will pay at the corporate level. Congress has the right to do either. The realization, if realization is necessary, as long as it takes place at one of the two levels, it's there. In this case, they specifically ruled that the corporation had realized the income. And because of that, it's not required it be taxed in the year of realization. Congress has the right to defer. If you push that further, you say things like 1031 exchanges, makes it clear that you could defer the taxation, even though it's been realized. It might not be recognized till a later event. So they have any problem with that. That wasn't a problem for them, right? They noted there's no real difference between the subpart F tax on basically dividends, interest, that kind of stuff. If that's constitutional, then the 965 transition tax has to be. So either the subpart F tax, which has been ruled on by the courts, multiple times as being fine, if that's constitutional, then the transition tax, which simply adds on top of that, has to be constitutional. And the Moores conceded that, the subpart F tax constitutional. They also had argued that, there were special rules and special reasons why it was fine for Congress to tax S corporation equity holders and partnership equity holders. They didn't buy any of that, right? The court's not buying it. When he wrote for the majority, he found a ruling otherwise would have resulted in a fiscal calamity, either very deep cuts in spending or much higher taxes imposed on basically individuals. Because in this case, with realization, or you would have had to push the taxes into the entity stuff, whole new laws passed by Congress. That was probably the nightmare scenario, because it seems likely Congress would have been fighting for quite a while over that issue. You couldn't have got anybody to agree on anything. And worst case scenario is that people began to lose confidence that the U.S. government could repay the debt, and all kinds of nasty things happen. So, I mean, even the Moores were like, no, we understand they're definitely not going to go there. Right? Last thing Supreme Court wants to be done is be blamed for that. Everybody tried to work around the problem. Justice Kavanaugh simply said the fiscal calamity is not required by the Constitution. But I find it interesting he discussed it because, if it's required, in essence, either the Constitution allows Congress to do this or it doesn't. In theory, does a fiscal calamity really change the answer? You could argue no. But in the real world, from a practical standpoint, for the Supreme Court, who realizes that if, in fact, they will be held to blame if things went really bad after this decision, I think it was a very important practical point, even if I don't think, in theory, it should have had any impact on the decision. But that's my reading of this. So Moore's not going to settle the issue for the wealth tax. And I think the court pretty well telegraphed, don't bring back another case trying to get us to rule on a wealth tax that doesn't exist, because we're not going to do it, right? We're just going to ignore that. So I don't care whatever thing you find, unless they actually pass a wealth tax. We're not actually going to tell you if that's constitutional or not. We're not going to give you a ruling in advance. Okay, next up, we're going to talk about IRS Notice 2020-455 came out also on June 20th. Now, the Secure 2.0 Act added two new exceptions from the 10% additional tax under Section 72T of the Code for premature distributions from employer retirement plans and IRAs, right? And specifically in this case, defined contribution employer retirement plans and IRAs, right? This particular one. It deals with emergency expense, personal expense distributions as defined by the law, and domestic abuse victim distributions, again, as defined by the law. Now, if you've taken, which hopefully you have by now, a course that went over what was in the Secure 2.0 Act, with basically under the statute, there are definitions for each of these, and they're relatively broad. So, because the IRS wants to go back and actually write regs on this, they have issued this notice as interim guidance. Okay. Now remember, as a notice, it's not in the same league as a regulation, not even a temporary regulation. However, I think you're going to find that obviously on exam, the IRS will follow this. I also think that the courts may be leery about getting too far off it because otherwise they got to come up with their own full theory. And so my guess is for now, certainly if your clients want to make sure that they don't have a problem, you want to make sure that you comply, that basically you fit your distributions within these definitions, or your client's at risk on an exam of the service deciding they can pay the 10% and they might lose the ability to put the funds back in. There is a rollover provision in each case that allows you to put the money back in for up to 3 years after the initial distribution. Okay. Now, let's talk about an emergency personal expense distribution, right? What it is. In the notice, there are 7 Q&As that discover the distributions in general, right? Including the definition of what it is. And then there are 8 Q&As that will go a little bit into issues with the plans. So let's talk about what these rule here. What is an emergency personal expense distribution? Well, it's one made from an applicable retirement plan, which essentially we'll talk about what that is here in a second, but generally IRAs, 401k plans, things like that, 457 plans, 403b plans would be these eligible plans for these cases. And it's to meet an unforeseeable or immediate family emergency related to necessary personal or family emergency expenses. And part of the reason here is to get a full definition of each of these. That's why it's being issued. It is includable in gross income, so you don't get excluded from income, but you don't pay the 10% tax. That's the big difference. Question A2 is now we get to what in the world is an unforeseeable or immediate financial need relating to necessary personal family emergency expenses. Whether you have those expenses for those experiments is determined by the relevant facts and circumstances. Factors to be considered but are not limited to whether the individual or family member has expenses related to the following list. Now, when the IRS does this list is a safe harbor. If you can show me expenses that are on this list, it's going to qualify. But you can argue something else that's not on the list qualifies. Okay? So what are some of the things that are kind of our safe harbor? Medical care, including the cost of medicine or treatment that would be deductible under Section 213D, determined without regard to limitations in 213A, which means don't worry about the 7.5% of AGI. If it would be deductible, it could go on Schedule A, ignoring whether or not you get any benefit from it because 7.5% of AGI limitation. That counts. So any of those expenses count, which means almost by definition, everybody's going to have some of this expense every year, whether or not that expense is, basically, we'll talk about the rules that would say you can't really take that money out every year without doing some other things, but basically it's there. Accident or loss of property due to a casualty, right? Imminent foreclosure or eviction from a primary residence. You're under that rule. Need to pay for burial or funeral expenses, right? Auto repairs, or any other necessary emergency personal expenditures, right? Okay, that last category is the catch-all, right? For purposes of determining whether an individual has an unforeseeable or immediate financial need, the administrators may rely on the employee's written certification that the employee is eligible for such a distribution. So basically, the plan administrator or the IRA custodian does not have to independently investigate whether the employee or the owner or the beneficiary of the IRA is pledging on their emergency need. They're allowed to take that on exam if the service determines that the employee did not have that, then they're going to impose a 10% penalty. But the plan, and this is probably a bigger problem for retirement plans, employer retirement plans, 401ks and the like, it's not going to be subject to, being disqualified because it made a distribution it wouldn't have been allowed to. It can accept generally the employee certification. They do have a portion at the end of this that asks for comments, and they are asking for comments in regs. Should there be cases where the employer would not be allowed to take the employee certification? I could certainly see that in cases where the plan or the employer had a reason to know the employee was lying, largely because the employee in question is 100% owner of the company, who also serves as the plan fiduciary. Well, that person would know. So we'll see if they do that. Which types of plans are eligible to make these? Now we got whole descriptions of these. It's a plan described in 402C8B, other than a defined benefit plan, right? Defined benefit plans are those that, are set up to pay some benefit for the life when the employee retires. So those sorts of things, traditional defined benefit plans, cash balance plans are in that category. Defined contribution plans are most plans that are out there these days. Includes 401k plans, profit sharing plans, similar structures like that. So in essence, a 401a qualified defined contribution plan, as I said, like 401k, would also include Section 403a, annuity plans, 403b annuity contracts, and governmental Section 457b plans, or the individual retirement account. Is eligible to permit an employee personal expense distribution. So those can put in their plans that they will allow an employee to take that distribution. How frequently can you take the distribution? You can only one distribution, and that is one distribution no matter how much of the maximum the employee takes out. Only one distribution can be identified for this exception. So even if they stay below the limit for the year, but they take it in two distributions, they can only flag one as their qualified, basically, emergency personal expense distribution. That is one of the limitations of this rule. The dollar value limit is found in question 5. It's the lesser of $1,000 or an amount equal to the excess of the individual's non-forfeitable accrued benefit under the plan or their total interest in their IRA, determined as of the day of the distribution over $1,000. So mechanically, you got to have at least, $1,001 in the retirement account or in the IRA account or in the plan that is vested, non-forfeitable, right, in order to take any sort of personal emergency expense distribution. The idea is you can't bankrupt the account, and you can't, if you're below you're 1,000 or below, you can't take the distribution, and you can never make the distribution, take it below 1,000, and qualify for this exception. So essentially, as long as you have $2,000 at least in the account, your maximum distribution will be $1,000. Right? If you have less than 2,000, then it will be it'll be the balance in the account as of the day of distribution, before the distribution, obviously, minus $1,000. Okay. So the example here is they have a 401k plan. On July 1st, the employee has a vested balance of $1,500. On July 1st, they request emergency personal expense distribution of $500. Not previously received one of those distributions. As we'll discover, that can be important. They have a non-forfeitable balance in Plan C over $1,000, is $1,500 minus $1,000 or $500. Therefore, they can treat $500 of the distribution as an emergency personal expense distribution. Again, the lesser of $1,000, or in this case, the $500 in the plan vested in their account in excess of $1,000. Now, if you've taken one of these, how soon can you take another one? So you treat that distribution as emergency distribution calendar year with which expect, with respect to an eligible retirement plan. No amount of any subsequent distribution can be treated as emergency distribution during the immediately following 3 years with respect to that plan, unless no amount, the amount of the previous distribution is fully repaid to the plan, or the aggregate of your contributions to the plan, right, or amount attributed by the IRA to the IRA by the employee since the distribution came out, right, in essence, is at least equal to the amount of the previous emergency distribution, right, that had not been repaid. So, for instance, right, as we have an example here, in this case, same facts. Employee A requests that distribution gets its $500, does not repay the distribution, but continues to make elective deferral to the plan. On August 1st of 2027, has an account balance of $5,000. 5,000 balance, contributed 3,500 in deferrals since the July 1st. Even though that $500 is still out there, which means the employee still has the right to repay that 500, we'll discover. However, we're going to find that it doesn't make a difference at this point, because since he's already put 3,500 back in through plan contributions, deferrals to the plan, he can now again take his distribution. So, if you're going deferring to the plan, you could repay by deferral, or which would give you a new deduction against it, but you won't get rid of that repayment. You won't get rid of that initial distribution. So essentially, though, if they're just deferring they're on the paycheck like normal, once the deferrals will start eating in and eventually repay the loan. So once we get that, not necessarily fully repaid, but either it's got to be repaid to the extent repaid plus what they put into the plan since the day of distribution. Once that gets up to the emergency distribution they claimed, and we're outside that year, because remember, only one distribution count per year, then they're allowed to take another emergency distribution. Can you repay the plan? Yes. 3-year period beginning on the date in which the distribution was received, you can repay it, and it will count as if it was rolled over, right? So it'll be under the rollover provisions for the retirement plan type in question, right? Now, the next thing we have is, well, what about the plans themselves? Let's take a look at the plan side of this thing. How do we deal with that? Number one, can you add this to your plan to permit emergency personal expense distributions? And the answer is yes, but you don't have to. So a plan can be modified. Plans have to explain under what conditions can money come out of the plan. So let's assume that's there. Now, here's where it becomes a problem. If we have all of that, you can make that distribution, right? We have those conditions. You can go ahead and put this in. If the employee certifies they have an emergency personal expense amount that would qualify for this special rule, then you can allow them to take that amount out of the plan, even if they don't otherwise qualify for a distribution. But a plan doesn't have to do that. However, if a plan doesn't do that, but the employee is eligible to take what we will call a permissible distribution, and that permissible distribution meets these requirements, then they're able to still get out of the 10% penalty. Right? We'll talk a little bit about how that would work. Now, a permissible distribution means a distribution that meets the distribution requirements for the plan and is permissible under the terms of the plan. So let's say you're in a plan does not permit emergency personal expense distributions, may meet the requirements for a hardship distribution if you permit those. If you've terminated service with accrued benefit that does not permit emergency personal expense distributions, you may meet the distribution restrictions for basically for severance from employment. So you can take the funds out that way. If you have a valid way to get out of the plan, even if the plan has not been modified to allow this specific type of distribution, the employee can still claim the benefits of not paying the 10% additional tax. Right? In question 9, yes, administrator of a plan can rely upon the employee or the IRA participant's statement that they qualify for an emergency distribution. Again, they don't need to go prove this or ask for evidence of it from the employee. Do these emergency personal expense distributions from Apple Retirement Plan meet the distribution restrictions, requirements, and sections in these various sections, right? That is it allowable distribution? And yes. Generally, it's going to qualify. You could have that distributions. If the plan allows it, it's another one of these allowed qualified distributions from a plan. So again, it's not a qualification problem. A plan can do this, which seems to make sense, but they said it. Is an emergency personal distribution treated by an applicable eligible retirement plan as an eligible rollover distribution for direct rollover rules? Section 402F notice requirements and the mandatory withholding rules. Why this is a problem is if you have a qualified rollover distribution from basically an employer-sponsored retirement plan, first, you have to essentially allow for a direct rollover to another qualified plan. So you have to go ahead and say, yeah, you can have it paid directly over to this other plan. Number two, you have to give a specific notice about the rights to that direct distribution or the rights to put the money back in after 60 days. And third, you have to have 20% of the distribution withheld. Not surprisingly, IRS has ruled no, this is, even though it's a distribution that under the 3-year rule could be rolled over, it's not a traditional rollover distribution because requiring these steps would essentially not make sense. It would not make sense to have a emergency personal expense, event, and then somehow that just lets you move the money out over into another account, into an IRA account or plan we otherwise could. Now they said, no, we're not going to, you're not going to require to do a direct rollover. You're going to give it to the employee. And you don't have to give them the big notices for rollover distributions. And you don't have to have mandatory 20% withholding, because that also would make little sense. You can take $1,000, we're going to keep 200 of it. Yeah, and then of course you come to the theory, well, obviously it wasn't used for emergency personal expenses, so is that one a subject to 10% penalty? Yeah, we're not going down that path. You do have to, under the rules though, it is considered a distribution from which taxes can be withheld if the employee, asks to do it, and it's covered by those rules. But there is no mandatory withholding rules. If an Apple eligible retirement plan permits the distributions, is the plan required to accept the repayment? Yes. If your plan is modified to allow emergency personal expense distributions as a standalone reason for getting a distribution, then you have to accept rollovers back in. So the way you have to do it, right? If you have that, must accept repayment of the emergency personal expense distribution. If the plan permits the personal expense distribution, the individual received emergency personal expense distribution from that plan, and they're eligible to make the rollover contribution to the plan at the time they wish to repay. Now, if in fact the plan does not have a provision permitting it, then no, the plan does not have to take the money back. We'll discover that here shortly. In essence, in that case, the employee is going to have to push it out to an IRA, right? They won't be able to put it back in the employer plan. But as long as the plan has, and it would still seem that the plan could still be written to accept the rollover back in under the special 3-year rule, but it doesn't have to. Okay? But if you allow for the distribution, you must allow the funds to come back. Right? That's it. Is a repayment of an emergency personal expense distribution from an Apple retirement plan or an IRA treated as direct transfer of the rollover distribution? Now, in this case, you actually are treated as even though you're not doing a trustee-to-trustee transfer, it's going to be treated for all purposes as if it was a direct rollover. Okay, that gets it out of the all the various special rules that relate to that distribution. And what's going to obviously happen is you include it in income in the year you receive it, unless you've already put it back in by the time you file the return. And if not, then you would have to file a claim for refund to get the tax back. And that's the reason for the 3-year restriction, because again, we have basically a 3-year statute to get the money back. So they're going to say, well, the simplest way to do it is say, you got to put it back in within 3 years. They're not going to try to explain to the person taking it out that, well, the statute wouldn't close on that year until 3 years from April 15th, unless you filed an extension, then it would go 3 years from the date no. We're not going to go down that path. They're just saying 3 years from the date received is when this special rule ends. They had initially filed this up in the qualified birth and adoption expenses distribution rules and then fixed that in Secure Act. Those initially had no limitation on repayment, but obviously you couldn't get the tax back once you went outside the 3-year statute. Is repayment of emergency personal distribution from an IRA treated as direct transfer? And again, yeah, basically the same. Direct transfer from one IRA to another. That's how the IRAs will handle it. And again, so they don't worry about the other issues. If you do not permit emergency personal expense distributions, may the individual treat an otherwise personal distribution as emergency personal expense distribution? Question 15 says, yeah. If you can qualify for a distribution under some of the provision of the plan, even though they don't directly allow the emergency personal medical expense or emergency personal expense distributions, you can still treat them that way. That's not a problem. We also now have the domestic abuse victim distributions, and this is arranged a similar way with the questions. The first 6 questions are about the distributions in general. Okay. What is a domestic abuse victim distribution? This is a general definition. Is a distribution from an Apple retirement plan to a domestic abuse victim during the 1-year period beginning on any date in which the individual is a victim of domestic abuse by a spouse or domestic partner. It's includable in income, but not subject to the 10% tax. Okay, so there will be a 1-year date. You've got to establish a date when they were a victim of domestic abuse, domestic violence. Okay, that's going to be key. And we'll talk about what that is here in a second. But then you're going to have 1 year from that date. Distributions during that term that meet the requirement would be exempt from the 10% additional distribution payment, and they would be eligible for being rolled back into the plan within the 3-year rule that we'll talk about. How is this domestic abuse defined for this purpose? It means physical, psychological, sexual, emotional, or economic abuse, including efforts to control, isolate, humiliate, or intimidate the victim, or undermine the victim's ability to reason independently, including by means of abuse of the victim's child or any other family member living in the household. Okay, so it's a fairly broad definition of domestic abuse. Obviously, if the person receiving the distribution is examined, the IRS can now act for the evidence of that, right? Challenge it. So you do have to remember, it is going to be the burden of proof on the person receiving to show that they were a victim of that. So be aware of that when we look at it. Which types of plans are eligible? Basically, again, the same set as before. Defined benefit plans don't count, but defined contribution plans count. But also there's an exception if a defined contribution plan is subject to the spousal consent requirements, right? And that's possible if the defined contribution plan has some prior defined benefit balances sitting in it. So it gets a little weird. And you're going to probably ask the plan administrator if they believe this plan is subject to the spousal consent requirements, in which case then you cannot take a distribution from that. So you got to be a little careful and know a lot about the plan to know if it's going to have this as its problem, that you need spousal consent. If you need spousal consent, you can't get domestic abuse victim distribution because you then need the permission of the abuser, which, yeah, that just might not work. So as I said, that's a different problem in that area, right? Okay, is there a dollar limitation? And this case cannot exceed the lesser of 10,000 index for inflation. Now, the 1,000 for the emergency expenses is not indexed for inflation, but this will be. Or 50% of the present value of the non-forfeitable accrued benefit of the employee under the plan. That'd be half the balance in the IRA or half the fully vested, half of the fully vested benefit in the employer defined contribution plan. That's eligible. So we have a 403B plan that permits these distributions. You're a participant in the plan on August 15th, 2024. They're eligible to receive a domestic abuse victim distribution from Plan E because they were a victim of domestic abuse on January 15th of 2024. August 15th is less than 1 year after that date. On August 15th, they have $15,000 vested balance of the plan. $7,500 is 50% of their vested account. Therefore, they request and can be given a $7,500 domestic abuse victim distribution from the plan. They're going to take that from the plan, and the $7,500 will not be subject to 10%, but it will be subject to general tax rules for a distribution. So keep that in mind. The cost of living adjustments are explained there on question B5. So it's going to be there. It starts next year. So 24 is 10,000. Will be above 10,000 next year. Okay. Okay. May an individual repay these? Yes. 3-year rule applies here as well. So you can put it back in within 3 years. Then we have 8 questions related to the retirement plans in these distributions. Similar to the domestic, to basically the emergency personal expense distribution, plans not required to be amended to allow these domestic abuse victim distributions. But again, right, if you don't permit them, but you're permitted to treat an otherwise permissible distribution as domestic abuse victim distribution, and that's back with the same definition we had for the emergency personal expense. It's just going to be a distribution allowed under the plan's terms, even though they didn't specifically add domestic abuse victims. So again, a hardship distribution could qualify for the domestic abuse victim distribution exception. Okay, question 8. Do domestic abuse victim distributions from the eligible retirement plan meet distribution restriction requirements in the sections, etc. of the plan? We've already told you yes. Again, this is just repeating what we had for the emergency personal expense distribution. There's no difference there in this case. What are the certification requirements? In this case, an employer, if they certify, in distribution that a participant certifies as domestic abuse victim distribution, we treat as meeting distribution requirements of the retirement plan. There are various ways they could check a box distribution request form to certify that they're ineligible for domestic abuse victim distribution, and the distribution is made within 1 year beginning on the date at which they were the victim of it. Certification must be in writing, so you need the employee to certify you in writing, and the employer participant may use the electronic delivery rules in the regulation 1.401A-21D to provide this certification. So again, the employer plan sponsor can take the word of the employee that they are a qualified victim. Okay? The rollover distribution rules are going to be the same here as before. It's going to be treated, we don't need to have the notice distribution, direct rollover distribution rules where we have to provide the right to throw it to another retirement plan or an IRA. Number 2, we don't need to give that whole description of those rights that normally goes out with that, and we don't need the 20% withholding, right? But you can have withholding, but the employee can waive that entirely. So yeah, as we go with that. If you permit the distributions, do you have to take the repayments? Yes, under the same conditions. Your plan permits a domestic abuse victim distribution. The individual received one. They asked for and received a domestic abuse victim distribution from the plan, and they're eligible to make a rollover contribution to the plan at the same time. They wishes to repay the amount done. We're not outside the 3-year period. So that's in that background. And it would appear, though they don't really say it, that if they technically applied for the distribution as a hardship distribution, but it met as well the domestic abuse victim distribution rules, they could have applied and said they were requesting under that, it appears they would still be able to make the rollover into the account. But if the plan does not permit a domestic abuse victim distribution, the employee could take a distribution, say a hardship distribution, they're qualified for that, and then take advantage of the 10% exception, but the employer plan does not have to accept the money back. Again, as with the other one, the employee could then use an IRA to hold it. Is it a direct rollover to the plan? Yes, it is treated if you pay it within 3 years as if it was a direct rollover. Similarly, for the IRA, treated as if it was a direct rollover to the receiving IRA plan. Okay? Question 14 is what we've talked about before. The plan didn't add provisions to allow domestic abuse victim distributions as a separate category, but you're eligible for a distribution, then yes, you can still take advantage of the rule. That's not a problem. Okay, next up, and finally for this week, the IRS enters the next stage of employee retention credit work. Review indicates vast majority show risk of being improper. This Internal Revenue Bulletin News Release 2024-169. It was also issued on June 20th. June 20th was a busy day, right? The IRS has been under pressure here to start processing ERC claims. The taxpayer advocate has been pushing for it. There definitely have been a lot of public articles and comments on the issue. So the IRS is now feeling, it's become time where the service felt they needed to give an update on what they're doing. Because what's basically happened, as most people tell you, there has been very, very little, if anything, paid out since they put the moratorium in back in September of last year, right? Not really much has gone on. So they issued a news release outlining the results of the review of the pending claims and a limited roadmap for the processing of returns they have now. Right? So let's talk about this. The review found that's going to divide it into three categories. So of the claims they have, they're going to divide them down into three categories. Between 10 to 20% of the claims they had on September 15th of 2023 fell into what the agency has determined based on their review to be the highest risk group. It shows clear signs of being erroneous based upon the information the service has and what's in the claim. Right? For instance, there may have never been 941s filed would be one of the issues. The entity does not appear to have any employees. It's never had one, didn't issue W-2s, various other things that they say, yeah, it makes it highly likely that this is not. Based on the information they have, it appears this is a slam dunk disallowance. Okay? They will begin in the coming weeks issues denying tens of thousands of these claims. And don't be surprised if there are some other consequences. Because remember, these people had a time period when they could have withdrawn their claim, right? They also had a time period when they, if they got paid, they could have repaid. That doesn't really matter because we're talking about claims that hadn't yet been paid. But yeah, they could have withdrawn the claim. The withdrawal period ended. And effectively, I think the service takes position now, have this news release coming out, it's too late. There are ways to still try to withdraw if you haven't been contacted by the service. But we'll see how they feel about this since they've just announced they're going to be issuing tens of thousands of denials in the next few weeks. They might, start saying, nope, you were scheduled for full denial. You failed to come in here and, withdraw. We gave you the chance. So tough luck. We're giving you full denial and we're imposing certain sanctions upon you for having filed a frivolous claim or whatever else they might end up doing, or they could be referring it to essentially CID or potential criminal activity. So yeah, it could get bad, right? The review also found that between 60 and 70% of the claims show an unacceptable level of risk. What the IRS means by that is they don't show by themselves, the IRS does not have enough evidence to effectively prove that they're just cannot possibly be correct. But they have a lot of information that strongly suggests that this claim is incorrect. They're going to be doing additional analysis on these claims to gather more information with the goal of improving the compliance review, speeding the resolution of valid claims while protecting against improper payments. What this kind of seems to be saying backdoor is they're going to do more work on these and see if they go in the first category of clearly improper or the next category. Try to resolve them into one of the two categories. And I presume that could be done as well by having a full-blown exam. That's one of the ways we're going to clear these out between one of these two. But in any event, these appear to right now, they are not going to be getting a rejection letter. They're not going to be getting in the near future a rejection letter or a payment of the refund. Finally, there's 10 to 20% that are low risk. What that means is to the service, everything on the claim makes sense about why they would have the claim, about the amounts of the claim makes sense based on their payrolls. It appears the math is right. There's all these issues, so fine. Right? If they have no eligibility warning signs that were received prior to last fall's moratorium, the IRS will begin, as I said, judiciously processing more of these claims. That's not much of a promise that they're going to issue checks. My guess is they're still saying we're not going to just blindly issue checks to these 10 to 20, but we are probably going to start, processing them more quickly and trying to expedite them through the system to get to a resolution, which will probably be a payment of the claim. I think that's kind of the way to read that. So the problem is, though, your client does not know which category the service has assigned them to. Right? So that's one of the problems. Okay. Otherwise, the oldest claims, first thing is oldest claims process first. So in each of those categories, they're going to start with the oldest claims and work their way down to the more current ones. They also told us that they're not yet going to start processing any claims that were filed after the moratorium date last September. So they're not. So if your client filed in October, November, December, yeah, tell them they're still going to be waiting and probably quite a while. Okay. That's important for them to understand. The IRS will not move on these claims. As we discussed before, there are not real good ways to make the IRS move on these claims, except for the sledgehammer approach. Remember that if a claim has been with the IRS for more than 6 months, and essentially anything filed before the September moratorium date has been with the service more than 6 months, the taxpayer can force the issue by filing suit in U.S. District Court or the Court of Federal Claims. However, the problem there is being cost effective. If you're looking for a $20,000 ERC claim, refund claim, it's almost certainly not going to be cost effective to start up a district court or court of claims case. The legal fees alone will eat you alive, before we get to trial. And, you'll force things fast, and you might not speed things up at all. Once it's in court, it's on the court's time frame. So, yeah, we may still have a long time to get paid. So, not really there. Again, as we mentioned a couple weeks ago, there are a few cases making their ways out, but they're a very, very low number. Again, I don't know how many people, when people are going to take it to the district court or the court of claims, but that is really about probably the only option out there. I know, as I've said before, we've told you there are a couple of suits, well, one in particular, that's pushing now to force the IRS to start, paying these claims out, making decisions on them. The problem is, I think if you do that, they just disallow if they were forced. And then that puts you into 2 years to file suit. You have to go to district court, or we let it continue. So again, no good answer. If your client's here, yeah, it's a problem. If you have a client that it is very obvious based on the 941X you filed and based on the law as it exists, if it is clear, and I'm going to tell you that at this point, it's the IRS making this decision. So clear means that it definitely meets all the requirement of the 2021 notices, right, to qualify for the payment. Then and only then, do I think your client might have some glimmer of hope that a check will arrive, before, somewhere in the summer. And they do say they'll start paying them out this summer, which, remember, could literally be into late September before payments would start. So yeah, don't say that. That means that next week a checks will start arriving. But some of your clients with totally clean claims, and the 941 itself is clean. There are no questions for the service to ask, and which is what I always told people. You want to get your claim to stand out and be clearly okay. So yeah, we need that done. That's going to be key. Well, this has been the current federal tax developments for the week of June the 24th, 2023. Current federal tax developments are brought to you by your state Society of CPAs and Kaplan Financial Education. Don't forget, you can contact me, edzottos@currentfederaltaxdevelopments.com. You can also post on the Connect sites for the Arizona, New Jersey, Illinois, basically an Idaho Society of CPAs. And if I see your message there, I may respond. Otherwise, yeah, we'll hopefully see you next week. I do have a lot of, let's see, this week I actually have, 3 full-day sessions that I'll be giving, or, one day is 2 4-hour sessions. Yeah, it's going to be a much more active week. I don't need to travel anywhere for these sessions, but I do have to give the session. So I'm going to be doing a lot of that work this week. So I probably will be mainly doing client work and giving those sessions because the week's going to get a little full. And I have some other things happening that have suddenly arisen that are going to make it a little more interesting to manage things anyway in the short term. So yeah, could be fun, but I should be back next week with another update, and we'll talk to you about what's going on in the area of current federal tax developments.